Well, kia ora everybody. Greetings from the Tararua down in the Wairarapa, where I'm holed up during this lockdown level 3. Look, today there was a fascinating, interesting story in the media, one that could have massive negative impacts for temporary work visa holders. And I'm referring to the Employment Relations Authority decision today. An unbelievable decision where they've ordered restaurant brands to pay $18,000 to one of their workers because the ERA says they failed to support Dilshad Gill's work visa application and justifiably dismissed him in 2019. The ERA says that Gill was hired on a permanent basis as an assistant restaurant manager or general manager at one of the company's restaurants in Johnsonville in 2017. Now, this is simply a legal impossibility. It is not legally possible to offer a foreigner a permanent employment position. They're on a temporary visa. The visa expires at a certain date, and in this case, Mr. Gill's visa was due to expire on the 7th of March 2019. Now, Mr. Gill, understandably, he asked restaurant brands to offer him continued employment, and that's understandable. That's November 2018, and that's when he went to them because his visa expired in March 2019. Mr. Gill was very upset because restaurant brands told Gill that they had to go through a recruitment process. Now, as we all know, that's the legal reality. Restaurant brands, like every employer in New Zealand, under immigration rules, must first go through a process to advertise all jobs for essential skills work visa in order to see if there are New Zealanders available, New Zealand citizens or the holders of New Zealand resident visas. And if someone is available who's qualified for the job, the employer must give the job to the New Zealander. And that's tough for work visa holders like Mr. Gill, and they will be understandably upset. I accept that, but that's the law. Now, Mr. Gill told the ERA that it did not occur to him that he would need to apply for his own job, as he believed he was a permanent employee, and he claimed that he just thought he was going through a simple administrative process. Well, sorry, Mr. Gill, that's just not believable. Your work visa clearly stated that your visa expired on the 7th of March 2019, and Immigration New Zealand would have made it very clear to you in their correspondence back in 2017 that there was no guarantee that you would get a new work visa. Now, on 21 January 2019, Mr. Gill applied for the job. Restaurant brands went ahead and advertised position. He applied for it, and he believed he would automatically be given it because he was the current incumbent. But in February, he was advised by restaurant brands that they had offered that position to someone else, a New Zealand citizen who was qualified for that role. Now, that's exactly what the law requires. And yes, I understand it's distressing for temporary work visa holders like Mr. Gill. But restaurant brands, if they had offered the position to Mr. Gill, they would have been acting unlawfully, and they could have been prosecuted for it. Now, restaurant brands told the RA that the job was offered in 2017 because back then they advertised and couldn't find a New Zealander, and so that's why they gave him the job, and that's fine. That's totally within the rules. And they also believed that if they had offered the job this time around, it would have been rejected by Immigration New Zealand, and that's absolutely totally correct. As I said, legally restaurant brands could not have offered Mr. Gill that position because they had identified a qualified and suitable New Zealander. And Restaurant Brands also, according to the media anyway, and stuff, said they didn't want to waste $495 on an application. Well, because it might be automatically rejected, which it would have. My only observation there is Restaurant Brands must be a pretty good employer if they're out paying the application fees for some of their staff. There's no legal requirement for them to do that. That's Mr. Gill's application, and therefore it's his obligation to pay the fee, his responsibility. And also, contrary to what the story says in the media, and contrary to what Mr. Gill seems to be saying, employers, such as Restaurant Brands, they cannot apply for a visa on behalf of their employer. All they do is fill out the employer supplementary form. Now, the ERA member, his name is Jeff O'Sullivan, said Restaurant Brands was obligated to let Gill know that it was not intending to support his application and the reasons why. Well, from what I've read in the media, Restaurant Brands did exactly that. They told Mr. Gill that they were required to first search for New Zealand to fill the position, and it was a New Zealand citizen that they found. Further, Mr. Gill knew at all times that his right to work expired on the 7th of March 2019. It was not up to Restaurant Brands to keep reminding Mr. Gill of that. That's Mr. Gill's responsibility. Restaurant Brands' obligation was to make sure that they did not employ him on the 8th of March if he didn't have a visa. And further, there's nothing in New Zealand law that requires any employer to support a work visa applicant. So, ERA member Mr. Jeffrey O'Sullivan goes and finds that Restaurant Brands had failed to act as a good employer. They went ahead and awarded Mr. Gill $18,000 for hurt and humiliation. Look, my suggestion to Restaurant Brands is you must employ this decision, this ridiculous and unlawful decision in my opinion, to the employment court, because it will have disastrous follow-on impacts if it's allowed to stand. Because all of a sudden you're going to see hundreds, perhaps thousands of temporary visa holders going to the ERA and getting $18,000 settlements. And further, my last thing there, Jeff O'Sullivan, if you ever get to listen and watch this video, you need to read up on the law, bro. Kia ora everybody, thanks for listening, I hope it's useful. Take care, down here on the farm, sheep behind me. Kia ora.